captivity, and the Prime Minister, and another.
Mr. Herman.
Yeah, please, my lord, my lord. I appear for the claimant together with Mr. Evans, Mr. Craven. My lord friends, Sir James Eady, Mr. Blundell, Mr. Knight, and Mr. Howell appear for the defendant. My lord, can I just start by checking we all have the same paperwork? I very much hope the court has two bundles of authorities. It has a core bundle and a bundle of exhibits to Miss Spurrier's statement, a bundle of Scottish proceedings. I hope you were also provided with the third statement of Miss Spurrier yesterday.
Were we? Remind me what it's about.
It's just appending some additional press reporting as to the defendant's intentions. Shall I hand up copies?
Would you? Because I'm not sure they've gone into the bundles. Thank you. Okay.
I hope the court was also provided or sent a letter from the Speaker's Council
I've not seen that.
Could I just indicate this and just deal with it very quickly? There was a concern raised by the Speaker's Council that some of the materials in Miss Spurrier's statement, which record statements made in the House of Commons, may have offended the principle in the Bill of Rights that judicial proceedings should not impeach parliamentary proceedings.
You certainly can't rely on anything said in Parliament.
And as well, I'm certainly not seeking to impeach it, my lord, but I'm going to suggest to cut through all of that because I don't need it. I'm entirely content to rely purely on the extra parliamentary statement.
Well, I think, Mr. Herman, you may be getting ahead of yourself, if I may say so. This is an application for permission to appeal a case management decision, not to have an urgent hearing of a rolled-up application for judicial review.
Yes.
Essentially on the grounds that the matter is proceeding in Scotland and has been determined at two levels in Scotland, and there's an opportunity on Monday for the matter to be revisited. So we are fully aware of all the background. We've read the papers, and we would like to hear submissions first on the narrow point of the application for permission to appeal the case management decision.
Of course, my lord. I wasn't seeking at all to be presumptive. I was just seeking to get sort of housekeeping out of the way before we got on to anything else. Can I make one final point on that and then go directly to the question of permission, which is the cost capping order? That's not an issue that we've troubled the court over.
Well, it's not before us.
So, my lords, my lady, permission to appeal, and why we say with respect Mr. Justice Supperstone was wrong to put off the question of listing. It's based, our position is based upon two main factors, and we will also seek to distinguish why the position for the Scottish court was different to that before my lords and my lady. So the two important factors are these. Firstly, timing. If we are correct that our case on frustration is at least arguable, and for the reasons we set out in writing we say that it is, then the mischief that we seek to prevent is one that has either already occurred or may well occur early on Sunday. So what we seek to prevent is the defendant seeking to procure a refusal to a request that needs to be made on Saturday night at the latest. Now, if we are correct in our contention that it would be, or at least arguably correct in our contention, that it would be unlawful for the defendant to act so as to procure that refusal, then simply leaving it to next week to decide when to list the case would be far too late. And it would be late because the damage would have been done and there would be no remedy available. And it would be done with the results and in the context of a decision that, for right or for wrong, has undoubtedly a profound constitutional impact that affects millions of the residents of this country. The second basis is that the application is not based upon a fanciful or unevidenced assertion that the defendant might be intending, albeit inadvertently because mistaken, to proceed on an unlawful basis. Ms. Spurrier's statements, not least the third statement I provided with you today, and also Ms. Collier's statement, which in particular appends the text message from number 10 as to what their intention might be in respect of frustrating the Act, which is unchallenged, demonstrates that it is at least being considered from the European Council a refusal to the request that Parliament has mandated he must make if the deal is not agreed in Parliament tomorrow.
Well, there's a second condition.
Or, I beg your pardon, I'm so sorry, or Parliament does not sanction a no-deal exit. So we have evidence, unchallenged evidence, of a prima facie intent to act in a way that we contend is unlawful. You have the consequence, utterly profound consequence, we would say with great respect, utterly profound constitutional consequence, good or for bad, that will be by Monday morning potentially incapable of remedy. And we say it is the role and function of the administrative court to be able to respond timely to applications of this nature. Now, my lords, my lady, the position was different in Scotland. And could I just show you the position for Lord Pentland? And you'll find a copy of his judgment in Authorities 2 behind tab 21. This is a judgment handed down on the 7th of October. And the position before Lord Pentland was an acceptance of the defendant's submissions that he would not seek to frustrate the intention of the Act. And my lords and my lady can find that if you pick it up at paragraph 41, page 13 of the judgment.
Yes.
Council submitted that the Prime Minister and the Government have now made their intentions entirely clear. They would comply fully with all the requirements imposed by the Act and would not seek to frustrate its purpose. There was therefore no need for the Court to pronounce any order under the Act. And then in paragraph 42 you'll see that it is repeated just towards the bottom of that paragraph. Little c, the Prime Minister will not frustrate the purpose of the 2019 Act or the purpose of any of its provisions. What the Court did not have, it appears, before them on that occasion was either the clarification of the defendant's case that my lords and my lady would have seen in the Part 18 request in this case, nor would they have had the evidence in the public domain put into the public domain as to the actual intent that the defendant was putting into the public domain. Can I just deal with that and just show you what I'm talking about? It's an exhibit to the witness statement of Miss Collier, and you'll find that 314.
Yes.
And if the court would go to paragraph 4, you'll see that Ms. Collier says, after Ms. Fourier's first statement, the Spectator reported that a contact in number 10 answers the question as to how the Brexit talks were going. I'm going to show you a fuller excerpt in a moment. And then you'll see on the 8th of October, the former Home Secretary considers that's likely to have come from the Prime Minister's primary advisor. And it's, over the tab, page 318, is the Spectator print off from their website of the 7th of October. And you see the author, Mr. Forsyth, says, earlier today I sent a message to a contact in number 10 asking how the Brexit talks were going. They sent a long reply, which I think gives a pretty clear sense of where they think things are. And of course, this has been in the evidence before the court. It's not challenged. It's not suggested this isn't from number 10. And also, you'll see immediately from it, this isn't kind of a WikiLeaks recovery. This is on the record and intended, no doubt, for public consumption. And obviously, it needs to be read in full. But can I just, for speed, take the court to a couple of excerpts, please? Over the page at 319. Fourth paragraph. So if talks go nowhere this week, the next phase will require us to set out our view on the Surrender Act. The Act imposes narrow duties. Our legal advice is clear that we can do all sorts of things to scupper delay, for which obvious reasons we aren't going into details about. Different lawyers see the frustration principle very differently, especially on a case like this, where there is no precedent for primary legislation directing how the Prime Minister conducts international discussions. We will make clear privately and publicly that countries which oppose delay will go to the front of the queue for future cooperation. Cooperation on things both within and without EU competences. Those who support delay will go to the bottom of the queue. This source also made it clear that defence and security operation will inevitably be affected if the EU tries to keep Britain in against the will of the government. Supporting delay will be seen by this government as a hostile interference in domestic politics, and over half the public will agree with this. And then, just on the facing page, when they say, so what is the point of delay, we will say, this is not our delay, the government is not asking for delay, Parliament is sending you a letter, and Parliament is asking for delay, but official government policy remains that the delay is an atrocious idea that everyone should dismiss. Any delay will in effect be negotiated between you, Parliament and the courts. We will wash our hands of it, we won't cooperate in further talks. We obviously won't give given any undertakings about cooperative behaviour. Everything to do with a duty of sincere cooperation will be in the toilet. We will focus on winning the election on a manifesto immediately revoking the entire EU legal order without further talks, and then we will leave. Those who supported delay will face inevitable consequences of being seen to interfere in domestic politics in a deeply unpopular way by colluding with a parliament that is as popular as the crowd. So it's plain that sets out a position of number 10 that was not the position before Lord Pentland. Who proceeded on the basis of an undertaking that the government would not seek to frustrate the Act. Evidence suggests that...
It wasn't an undertaking.
I'm so sorry, my lady. I'm using that language loosely and incorrectly. It wasn't an undertaking. By a submission, which they were, but the position...
Well, it was more than submission, it was informal documents placed before the court,
Yes.
as here.
Yes.
And
But
Lord Pentland and the Inner House, in agreeing with Lord Pentland, described the unattributed statements, of which dozens were before them, as this wasn't their language, but I might be forgiven for using it, political noise.
well, my lord, one needs to distinguish between two types of evidence, certainly that we rely on, and that mirrors the position before the Scottish court. The first is evidence that in fact is no longer directly relevant, which is evidence as the position of the government as to whether they would send the letter at all. And The second is whether or not their view of the law of frustration enables them to do and to take steps to procure a refusal, which we say would be unlawful. So, just to be clear, I'm not saying that Lord Pentland was in any sense misled. I'm just simply saying this material wasn't before him. In the very clear terms, it is before this court and was before the women judge below. And that may be because the defendant has simply been misdirected as to what the Act requires, what the purpose of the Act is, and what the law of frustration is insofar as it impacts upon his obligations. So it's no part of my submission to say Lord Pentland was misled at all, but the position was not articulated, the position between the parties was not articulated with the clarity that it is articulated before this court. So, but ultimately, even if that position were not right, even if this was all before the Pentland, it doesn't appear to be so, but even if it were, we would say it doesn't matter because the first two core reasons I've advanced, the rights decision in any event is to determine this issue now, before it is too late, so that the Prime Minister can have the advantage of correction of what we say is a plainly legally erroneous interpretation of his duties, A, under the Act, and B, as to how the law of frustration applies to it. Because if it is left to next week, then the harm, that the legal wrong, is incapable of remedy. And my Lord, I can't possibly advance it higher than that.
Have you actually got a form of words that you'd be seeking in a judicial review if you were successful with the order?
Yes, ma'am. We've got a draft order. We haven't troubled the court with it yet, but I can certainly prepare. If you insist,
Well, I'm just interested in whether you've got just very general words or something very specific.
Could I hand up a copy of the draft that we're proposing? So it's a paragraph 2, and I'm proposing in substantive submissions if the court were to grant permission to appeal to seek to justify through developed submissions as to why we contend that may be an appropriate form of order in this case.
Well, just going straight to the heart of it, is it Liberty's submission that the Prime Minister should be precluded by law from stating his honest opinion about the desirability of an extension?
Absolutely not, my lord.
Is it their position that he should be prevented from explaining why it is his honest opinion?
Absolutely not. The caveat, the rule of the legal, hard legal-edged line, is what the Prime Minister cannot do is any act, which would include a statement, any act that is designed with intent to procure a refusal from the European Union. It is inherently unlikely that the mere stating of the Prime Minister's well-known position as to the merits of Brexit, as to the merit of this act, as to the merits of staying in the European Union after the 31st of October, is inherently unlikely that any of those statements could be taken as an intent to procure a refusal.
Even if he's seeking to persuade people that his view is correct?
Well, the difference would be if he said, consistent with the memorandum that the text that we've just seen, perfectly permissible for the Prime Minister to say, this is a terrible bill, it's a terrible act. What is impermissible, because on trite principles, it would be constitutionally improper. The Prime Minister is not entitled to say to our European partners, if you don't refuse the request for an extension, then we will take steps X, Y, and Z.
I find this a bit perplexing because the answer, the reply to the Part 18 request didn't simply say we can take any steps we want. It was related to, as the Chief Justice said, it's related to statements about the government's policy. Whereas it appears from the submissions that we certainly saw in the Scottish argument for liberty, that you've just extracted the second sentence in that reply and simply talk about anything that may frustrate or that you intend to frustrate the Parliament.
Well, my lord, the answer needs to be seen in obviously in the context of the question. The question was a very broad question about the government, could the government procure a refusal? The defendant chose to answer that on a very narrow basis, tied only to what the Prime Minister may or may not say in respect of an answer. It didn't address the fuller question. It chose to ignore that. Answered only in respect of what the Prime Minister could answer if asked. But it made plain, even in respect of that, if the intent of the Prime Minister was to make a statement, whether unprovoked or in answer to a question, with the intent of that statement was to procure a refusal to the request that Parliament has mandated he must make.
So it all turns on intent, not on substance, but on intent.
Yes, and one of the issues, my lord, you'll see if we go through to a substantive appeal, is my learned friends argue that the frustration principle doesn't apply unless there has been a demonstrable effect, to which we say, on authority, that is simply not. So, to go back to the question raised by my Lord and Master Rolls, I mean, that question we find troubling. I beg your pardon, the answer we find troubling. But the position is a fortiori in the context of the evidence, unchallenged evidence, before the court as to what the wider intent might be.
You were originally pressing for the answer to be given and for there to be a hearing about whether it should be given. And when the answer was given, you didn't then make any complaint about that answer
My lady,
as being inadequate.
I'm so sorry. From a procedural perspective, that's absolutely right, because we consider the claimant, I beg your pardon, the claimant, the appellant considered that answer revealed an intent of the defendant that required the urgent intervention of the court, because it, taken with the other materials in the public domain, suggested that the government had an interpretation of the Act and an interpretation of the law of frustration and a desire to take certain steps that would be unlawful. So the Part 18 request served its purpose in that it identified and crystallised the issues and indeed underlined the urgency and importance. There was no need in those circumstances to come back for a further clarification because, as far as the appellant was concerned, the position was then clear. So, my Lord, my Lady, unless the court considers that the underlying merits of the judicial review are relevant to the exercise of the relevancy or decision of permission to appeal or appeal, those are the submissions I advance in respect to the commission.
Thank you. Oh, that's very clear, Mr. Herman. Sir James.
My lords, my lady, I'm going to take, if I may, the skeleton as read, the summary grounds as read, the ruling of Lord Pentland as read, and the ruling of the Inner House as read, if I may.
You may.
The court will read those. So far as the challenge to the order of Mr. Justice Supperstone is concerned, you will need no reminding, I suspect, of the strictness of the test for interference with case management decisions by, in this case, the lead judge of the administrative court. If you wanted the authority, we referred to it in our skeleton, paragraph 38, it's BCP Holdings and the Revenue Authorities, bundle 2, tab 26, and the relevant paragraph, it may just be worth turning it up very quickly with the trouble of producing the bundles, tab 26 in volume 2, if you would. precise source of the statement of principle in paragraph 33. And it's particularly the passage just on the letter D on page 2957. However, found by the court to read from there to the end of the paragraph, just to remind you. So it's the Supreme Court relying on an earlier statement by Lord Justice Lawrence Collins, who was in the Court of Appeal and Walbrook trustee. It's that quotation which the unanimous Supreme Court adopts. That test isn't addressed in a learned friend skeleton, and it isn't, we submit, met on the facts of the case. 3 submissions, if I may, in support of the judge's entitlement to make this kind of case management decision. But firstly, that the attempt to distinguish between the Scottish proceedings is, we submit, untenable. The frustration principle was squarely in issue in the Scottish proceedings on a materially identical basis. It was subject to detailed consideration at first instance and on appeal in the Inner House. We've set out the factual position in our skeleton for this hearing between paragraphs 20 and 24. And in particular, just to show you a couple of references from the bundle containing the Scottish materials. I know the court was interested in the getting a clear understanding of the Scottish proceedings. Take up that one, I think it's the second of the volumes that you have for this hearing. And if you go first of all to just be a bit careful of the index, I should add that at the beginning. We've referred in our skeleton to Vince 1 as being Lord Pentland and Vince 2 being in the House. Here in the index it's been done in the order in which the petitions were actually launched. So the Nobilia Officium one and the appeal, but in the end they all got merged in the Inner House, which considered the appeal, as you know, and also the application relying on Nobilia Officium for a court clerk effectively to sign the letter if there was reluctance to do that on behalf of the Prime Minister. But I was going to take you, if I may, to tab 3 in that bundle and to paragraph 3.9 in this document, which is the note of argument. You'll be aware of the way in which the process works in Scotland. You have a much shorter form of formal pleadings in which answers are given, and then everything crystallises into the notes of argument, which are our equivalent of skeletons. It's 3.9 for present purposes in this. And you can see this is their note of argument level for the outer house. And if you wanted their pleading in the outer house.
This is, forgive me, this is the petitions, yes.
This is the petitioner so far. And their pleading, which launched the claim, is at tab 1. That's their equivalent of particulars of ground. And the relevant paragraph in that document, it is 14, but there are paragraphs of 14 to 15 pages. Yeah, paragraph 14 to 15. They're long paragraphs, which you'll see, but the basic thrust of them is that there's a reasonable apprehension that they will either not comply with the Act or breach the frustration principle because of the various statements of intention they relied upon in Scotland. And you see that the relief that they claimed on page 15, which was recited in the judgment of Lord Pentland, but you see it under Roman 1, to interdict or injunct the first respondents, the Prime Minister and the other Minister of the Crown, anybody acting on their behalf of their request from taking any action that would undermine or frustrate the will of Parliament as enacted, and so on, particularly by but not restricted to sending another letter, various specific ways in which it's pleaded in the claims for relief. Then if you go on in the bundle to the note of argument that was put in on behalf of the government in that case, that is at tab 9. Sorry, the wrong reference. And the other house, it is at tab 4. And you will see in particular paragraph 8 on page 42 of the bundle. In particular, note sub B at the very end in the last and penultimate lines of paragraph 8. And you will see the nature of the substantive pleading on the principle of frustration of paragraph 10. And that probably is worth reading, even though it's a slightly longer paragraph, but you'll see the detail into which that pleading goes.
Well, this is I think precisely the same language as is in the pleading
You won't be surprised if
before
it's
us.
it exactly replicated in the summary grounds.
Yes.
So the same points, the same argument, the same language is being used in both sets of proceedings.
Well, I think more to the point, you say it's exactly the same language in the reply to the Part 18 request. Is that
And what it is, although there are two sentences added in the Part 18 request in the second and third, or the first and second, but we respectfully submit, I'll come to that, we respectfully submit that they don't alter the substance of this, because what this paragraph is doing, particularly paragraph 10, that's equivalent in the summary grounds, is, if you will, to be staking out the reserved area, and that is done in identical terms. And then in the inner house, effectively the same position is adopted, and in particular one sees in tab 10, paragraph 5.23 of the petitioner's note of argument in the inner house. You'll recall that by this stage I said that two petitions had joined together, effectively the appeal from Lord Pentland and the Nobilia Officium. And you see in particular in paragraph 523 on page 110, if you would, about 6 lines up from the bottom, there's a sentence beginning further. It is clear that the statements of the United Kingdom government, including the Prime Minister, is seeking to undermine and frustrate the will of, you see all that? And you see the various ways in which that is done. So issue is there joined as well, and just for good measure, in response to a point made on my phone this morning, if you go back to tab 6 in the same bundle, and you go to paragraph 1.6,
This is the grounds of appeal.
it is the grounds of appeal.
Yes.
Rather unfortunately, none of these Scottish documents appear to be dated, so one doesn't know, but the sequence of it was 7th of October, Lord Pentland ruled. I think 8th of October these grounds are put in, and 9th of October the inner house holds its hearing. I believe I'm right in saying that this document and paragraph 1.6 is on the 8th of October. And the significance of that you will recall, and in particular when you recall that the inner house sat on the 9th of October to hear the appeal, including all the issues around frustration, if anyone wants to make those points. The point to bear in mind is that that Spectator article and the statement from number 10 on which my learned friend relied this morning were, I think, either before or on the 8th of October. And as we recall, the Scottish petitioners did effectively what Liberty have been doing, which is to produce almost daily updates of any statement made by or on behalf of the government. So, but it matters not. The fact of the matter is that the Scottish proceedings went to the inner house, the issue of frustration having squarely been before Lord Pentland, having squarely been before the inner house.
Was there anything particularly in the grounds of appeal you wanted to refer us to?
I think it was paragraph 1.6, which is that reference to immediately contradicted by the PM's statement. Pretty sure that's a reference to either something connected with or to that article.
Pretty sure, Sir James?
Well, I'm pretty sure it's simply because of the dates.
Yes, okay.
I mean, I can't tie it down entirely because those grounds of appeal were not dated on their face, but they must have been put in. And my recollection is they were put in the day after Lord Pentland rather than on the day he gave judgment, with the hearing in the inner house the next day. Sorry, one other reference I should have given you behind tab 10 in their note of argument. That you will see that they also, in 526 of that document, 5.26 on page 112, the claimants there, the petitioners in Scotland, also claimed that unless the matter was determined before the 19th of October in this case, the claims would be rendered futile.
Sorry, which paragraph is that?
5.26. And so frustration is then addressed and dealt with in terms by Lord Pentland. I don't know if I've turned up again because you've read it, but in what we call Vince 1, authority 2, tab 21, see in particular paragraphs 42 and 54 to 59 on the terms of the order. And then the inner house, next tab, authority 2, tab 22, paragraphs 6 to 8. On the reclaiming motion or the appeal, they affirmed his ruling for the reasons that he gave. So the premise for this appeal against Mr. Justice Supperstone's order is we respectfully submit mistaken. The frustration issue was considered in Scotland. Essentially and substantially the same points were being made, based, it appears, on even some of the same material that Onyphone now seeks to rely upon. And the judge therefore made no error making his case management order and deciding the application on that basis. And we note for good measure that the Northern Irish courts adopted a similar course to the course that the judge adopted, staying with liberty to apply, in effect, following the inner house ruling, in a case where again the frustration issue formed a prominent part of the pleaded case.
That was a stay by consent.
It was a stay, I think it was, my lady. But you see the background to it, the pleading and the inner house judgment. The pleading, if you want it, is in bundle 2, tab 14, pages 137 and 138. So on that's the Scottish proceedings. Then my learned friend says, well, everything changed in the Prime Minister's response to the RFI on the 9th of October. But as you think those vocal support, that isn't, we respectfully submit, a fair reading of the Part 18 response or the summary grounds as a whole. It was already and has always been the government's case that it could set out its views to the European Council and to other member states about the desirability of an extension. See the summary grounds, paragraph 18, which replicated the form of the Scottish pleading, unsurprisingly, as you've seen. The Prime Minister's opposition to the Act and to an extension is now, it may be thought, extremely well known and pleaded in the summary grounds, paragraph 18.3. And it's clear from those grounds we respectfully submit that the government believed it could set out to the European Council if necessary its opposition to any extension. The Scottish petitioners evidently understood that to be the Prime Minister's position without the RFI, because they make those points precisely in their grounds of appeal at paragraphs 2.1 and 2.3, tab 6 of bundle 2. And so far as the second answer is concerned, it's clear from the second answer to the RFI that the Prime Minister accepts that any request made under section any request made under the Act to the European Council would be valid, of legal effect and capable of acceptance, and could only be withdrawn in accordance with section 1.5 of that Act. There's nothing to suggest that the Prime Minister believed that he could lawfully encourage the European Council to treat that request as anything other than valid, of legal effect and capable of acceptance. And the Prime Minister does not suggest that he could do so. So the judge was entitled, as the first point, and correct to consider that there is no material distinction with Scotland. The second submission we make is that of three, is that the judge, we submit, correctly, and at least was entitled, to refuse to determine the claim as of now. The factual position is this: you've seen the pleading, you've seen the reservation of what I call the staking out, the reservation of territory, the reservation of position in the pleadings. The government's position and the Prime Minister's position on extension is extremely well known. There have been public statements of the strong desire, the strongest desire, it might be thought, for there to be no extension, despite the passing of the Act. But the time for compliance with the obligations imposed by the provisions of the Act is not here yet. It's midnight on Saturday. It is a matter of public record that everyone on the government side in recent times has been devoting their efforts and their energies to trying to get to the position of a deal. In other words, to get to a position in which the condition in section 1.1 of the Act is at least capable of being accepted and fulfilled. That is something which, of course, has to be put to Parliament. And that is plainly an important part of the purpose of the Act, given the condition in section 1.1. But a deal has now been reached. It has now been endorsed by the European Council. There will be parliamentary scrutiny by both houses at a special sitting on Saturday, at which many things can happen, including that condition 1.1 is fulfilled. So we are in a very different world today to the world we were in before today or yesterday. The conditions might be met, the factual position remains unclear because it is evolving moment by moment. What frustration means, indeed what is really plausibly likely, must be very different now. And it might be thought that Mr. Justice Supperstone could reasonably be sitting there thinking, I told you so. But if the condition is not fulfilled, the obligation to send the letter remains. But as I say, the world we sit on Sunday, whatever may happen in the myriad of events and possibilities on Saturday, the world we sit in on Sunday may look very different to the world on Friday for obvious reasons. And the question as to what position is then taken by the government in whatever events have occurred on Saturday in relation to future discussions and things with Europe is moot at this point. And it's moot for the obvious reason that you can't actually decide what your policy position is going to be, or what views you hold, until you actually know what events have occurred on Saturday in particular. And it cannot, we submit, be sensible or appropriate in that state of affairs, a fortiori in the world that confronted Mr. Justice Supperstone, but even as of today, it cannot be sensible or appropriate for the court to start trying to determine a challenge of this kind, which will require it to engage with and consider real facts, real positions in the real world that now inures. I should add, there is no dispute about the court's ability to grant advisory declarations, but the basic principle established by all of the authorities when you have to go to, for example, Lord Justice Lloyd Jones, as he then was in Yalland, that we referred to in our skeleton at paragraph 45 in the authorities at tab 9 in volume 1, when you have to go to that to see that the principle is that an advisory declaration should not be granted where there is any significant factual or legal uncertainty. That is precisely the course adopted by the Inner House, which deferred consideration of the Scottish proceedings until at least the 21st of October. It remains to be seen whether they are prepared to engage in the issues even on that date, or whether they will take the approach of saying, well, still things are not sufficiently clear because no firm positions have yet been taken. So our submission is that the court can't sensibly grant declaratory relief or enter into this exercise, save until there are at least reasonably clear facts providing a live context. And the principal course is to abstain from ruling from the time being until that is clarified. As I say, at its very bottom, it may be entirely unnecessary for the court to engage in this sort of exercise, because the condition in section 1.1 of the Act may be fulfilled, and Parliament may approve the deal that has been done with the European Union. And even were they not to do so, the world looked very different thereafter. And it shapes the argument, it shapes the nature of the frustration. Is it really to be said that the Prime Minister cannot go to Europe after Sunday, assume that the deal does not get approved by the Parliament but is roundly rejected? Let's assume that. Is it really to be said that the Prime Minister cannot go in those circumstances to the Europeans and say, well, we did a deal. I understand your position, which is you're not going to go any further. We reached an agreement. I tried my best to put it to Parliament and they weren't having it. My view is that there's nothing further that can usefully be done. There is no purpose to be served by a further extension. But he will know, as the Europeans know, if the letter has been sent, which it would be in that circumstance by midnight on Saturday, he would know, and the Europeans would know, that that was as it were, a legally valid offer capable of being accepted by the Europeans for good reason or none. And it is, with the greatest respect, particularly so now, utterly fanciful to suppose that the Europeans are not entirely aware of the fact that this Act exists, of the fact that there is a legal requirement to send the letter unless that condition is fulfilled, and of the government's thoroughgoing opposition to the prospect of an extension. But all of those things are now put into very sharp relief by the fact that there is this deal, by the fact that Parliament will now consider it, and by the fact that there will, by 1 minute past midnight on Sunday, be another brave new world. My submission is that the position, therefore, is that you are squarely within the thrust of the authorities that govern the making of advisory declarations. The third submission we make is that there is no question of the underlying claim being stifled by the judge's order. The Inner House, like the judge, was well alive to that issue. You saw the plea that it would be stifled, in effect, it would all be too late in the note of argument I referred you to. proceedings over to the 21st of October. So that any remedy was not, precisely so that any remedy was not rendered ineffective as a result of the passage of time. And the events of the last couple of days, we respectfully submit, underline the wisdom of that approach. So the Scottish courts were well aware of timing issues. In relation to the way my learned friend seeks to put timing this morning, the past is the past so far as that argument is concerned, and we would add the future depends on events. And it may be said, if my learned friend is truly saying, well, it'll be too late by 3 minutes past midnight on Saturday, or by Sunday morning 9 o'clock, assuming anyone is allowed to sleep, it'll be too late by then. It's not entirely clear when he anticipates a ruling of this court. That it may or may not be possible for a court, if it were to proceed to the substantive hearing day today, to give judgment today. My respectful submission is that there's nothing in truth in the timing point that hasn't been there all the way through. Who says that the European Council will reach a decision on Sunday? Highly unlikely that they would, I would have thought. So in those circumstances, we do respectfully submit that the learned judge was right, and if you transpose the learned judge's decision into the position which confronts us today, he would still be right. And he would still be right because whatever else may be unclear, it is absolutely clear that there is a really significant turn of the kaleidoscope happening on Saturday, and unless and until that brave new world is clearer and apparent, and the government's position in relation to it is clearer and apparent, it would be inappropriate for this court to engage in the exercise. Those are my submissions on the application. Will you just give me 1 moment? Forgive me for turning my back. Yes, some checks have been done, and the Spectator article was referred to in the inner house by the petitioners, as I understand.
Thank you.
For what that's worth.
Yes, I have a question. Going back to the point I made earlier, I mean, one of the central features that's made by the applicants in the present case is that it was the reply to the Part 18 request that changed things. You did seem to say in answer to my question that there was a little bit of difference between that and what was stated in our summary grounds of
Shall I identify that?
yes, could you just
I will, of course. The response, sorry, I've taken that with my mindful file.
So it's tab 8, I think.
Tab 8, thank you. Yeah. And you see on page 111, government's response clearly set out in 17 and 18 of the SGR, made clear it doesn't prevent and so on.
So that's exactly the same
That's
as
exactly the same.
as in Scotland.
That's the quote. That's exactly the same as Scotland.
That first is the same.
Exactly right. For the avoidance of doubt, those steps would be lawful whether or not their likely or anticipated or intended effect was or might be that the European Council refused to agree the extension. That's the new sentence,
I see.
so far as that one is concerned.
And
And in 2,
just before you go on,
Yeah.
those steps refer back, as I've understood this, to honestly stating his view or answering questions from as to the government's position.
yeah,
Yeah.
on the desirability or otherwise of any extension.
Yes.
Exactly. So, I mean, we get into intention being the natural state of affairs if you do something that leads to a predictable consequence. But that formally, that new sentence is the one I've identified. And I think in relation to the second one, I think again for the avoidance of doubt,
So just get your submission on that, following what the Lord Chief Justice said. Do I understand you to say that doesn't change anything of substance because it's referring back to the first sentence?
I do.
Yes.
It's clarifying the ground already staked out. Effectively, to stand back from it, the position that the government had taken throughout in Scotland and in England has been that what cannot be done is anything which undermines the legal validity or suggest that it isn't a valid request or that it isn't capable of being accepted. It's really the final sentence of the answer to request 2. Would be valid and so on. But the statement of government position, the statement of opposition, the expression of views is permissible because of the narrowness of the purposes. So there is nothing new in the second sentence of the response. It was simply designed to clarify. Hence, for the avoidance of doubt.
Thank you, Sir James. Mr. Hannah.
Can I deal with it in this order? Firstly, Scotland. Secondly, the political context and the changing political landscape. Thirdly, just a few additional comments and replies to the order of Mr. Justice Supperstone. And then fourthly, some general comments as to the approach the court, the judicial court to take. Scotland. St James has the advantage over the claimants in respect of the particular evidence that may or may not have been before the court and whether the spectator article was. I don't understand St James to be putting it in definitive terms. I certainly can't say it wasn't before the court, but I can say that Part 18's note in this form, as Sir James has identified, and that is important. And the court will find the answer to question 1 at page 111 of the bundle. The court will see that question number 1 is framed widely. I'm going to give you some context in a moment as to why it was framed widely. But it's to seek to ascertain whether the defendant contends that he may lawfully request, procure or encourage the European Council to refuse an extension if the 2 conditions in the Act are not satisfied. So it is a broad question that is met with a very narrow answer only in respect of answering questions if asked. But even in respect of that, the very material addition that was not before the Scottish court is that the defendant contends that even there he is able to make comments, even if he intends by those comments to secure a refusal. Now, 2 points. Firstly, this request was made not in a vacuum, purely by regards to the pleadings. It was made in light of comments by the defendant put into the public domain that suggested that there was a wider strategy of seeking to procure a refusal, not simply by answering questions when asked, but of taking further steps, such as, for example, seeking to procure a veto perhaps from Hungary, or, as you have seen from the text, taking a whole range of measures, including potentially threats as to what life would be like for the EU if they didn't grant it. So in the light of those materials, which have been properly evident and unchallenged before the courts, it was perfectly appropriate to ask the question in the wide terms that was sought. And we say troubling, firstly, that the answer is given in such a narrow sense, notwithstanding that evidence, but secondly, that the assertion is made, the one that wasn't for the Scottish courts, that the Prime Minister can lawfully act with an intent to secure a refusal. And, my Lord Lady, we haven't developed the merits, and I'm going to ask the court to treat them as arguable for the purposes of this commission. But the reason why that was troubling is because when one looks at the Act, if we look, for example, at section 1.4, that's Authorities 1, tab 2. If permission is granted, I'm obviously going to develop submissions as to precisely what the purpose of this Act is and why. But you'll see, not least from this, what Parliament has mandated is that the Prime Minister must seek to obtain an extension. Now, the methodology that is prescribed is by means of a letter. And we would say, in due course, if given the opportunity, that is Parliament taking absolute control over the Prime Minister in respect of it. It's not just saying you have to do that, you're free to do anything else. But the active words on which I rely here are the duty on the Prime Minister to seek an extension. And it would be plainly contrary to the will of Parliament if the Prime Minister acted with an intent, notwithstanding that obligation, to procure a refusal. And so that is why the answers to one, in particular the additional sentence that was not before the Scottish courts, is so important.
We don't want to get too bogged down in the merits of judicial review. I just want to understand precisely what you're saying about this reply to the request for further information, because you're resting a lot of your case on this to distinguish it from Scotland. So I really want to try and understand this. Is what you're saying, firstly, that taking the first sentence of the response, that the frustration principle does not prevent the Prime Minister from honestly stating his view to or answering questions from the EC or anybody else as to the government's position on the desirability of otherwise of an extension, that even that is impermissible and breaches breaches the frustration principle if the intention or likely or anticipated effect of stating those honest views would or might be that the European Council refused to agree an extension. Is that your position?
Well, ultimately, my lord, yes. But can I just break that down? Because it can be mistaken as being an overly bold position.
Right.
But
Your position being
my position being overly bold, simply by answering in the affirmative, it requires explanation. It is inherently unlikely that simply answering a question as to what the Prime Minister thinks about the extension is going to frustrate the Act, because it is inherently unlikely that it is going to procure a refusal.
But his intention, I'm finding, like my lord, this quite difficult. Let us suppose that the Prime Minister were to make a speech in Parliament on Saturday, setting out his position with clarity. The intention would be to persuade those around him, and no doubt those outside Parliament. Now, you wouldn't be able to impugn anything said in Parliament, but let us just suppose that the Prime Minister made precisely the same speech on a public platform outside. Politicians, when they make statements, when they explain their position, by and large are intending their statements to have a persuasive effect, aren't they? I mean, it seems to me if your answer yes, which must be the logical answer, it seems to suggest that it is Liberty's position that the Prime Minister is in truth prohibited by law from stating his opinion if in stating it he hopes that others might be persuaded by it.
Well,
that's a very extreme submission.
Well, my lord, I'm going to explain why actually it's the counter principle that's extreme, because the counter principle permits the member of the executive to ignore the will of Parliament. Actually, to take any other position it is inconsistent with our constitutional order. Can I at the outset, I put a plea in for explanation to a short answer to a short question, but if I can give that explanation. Firstly, it depends on who the audience is and who the Prime Minister is seeking to persuade. If the Prime Minister is seeking to persuade parliamentarians, obviously the Act has nothing to say about that. If he's seeking to persuade the members of the public, exactly the same. If he is seeking to persuade members of the European Council, and the purpose of what the Prime Minister is saying is to persuade them to refuse the request that he is going to make by order of Parliament, then yes, that would be frustrating the Act.
Can I just ask whether then it would follow logically that he's entitled to make those statements, provided he doesn't intend that anybody should act on them?
Yeah, I think intent, my lady, I think intent is probably the controlling word. And
Mr. Homer, you're making submissions to us, intending them to have an impact.
Yeah.
Any politician submission setting out his or her case. Isn't it the same?
Well, my lord, I am guided in what I can say to the court by the limit of my instructions and professional conduct rules.
Yes.
The Prime Minister is limited.
It's a broader point.
But the Prime Minister is limited in any act which frustrate the intention of Parliament that he seeks to secure an extension to Article 50. Now, whether that act is the intent to procure that refusal is through a threat, is through a bargain, or is through rhetoric, is irrelevant for the purposes of the principles of frustration. The Prime Minister can only act in accordance with that mandate. Now, my lord, there are detailed submissions
No, I
that
don't
I was
get
hoping
too
to make
much.
to convince you of that point.
I understand that, but I do think what emerges from your submission, which is very helpful as a clarification, is that everything turns on intent, and that even those matters in the first sentence of the response, if uttered with the intent specified in the second sentence, would contravene in your submission of liberty, would contravene the frustration principle. I think
Yes.
that's what you're saying.
Yes.
Do you make thank you, that clarified that. Do you make a second point, which I think you're making, by reference to the disparity between what you call the wide ambit of your request and the narrowness of the response? Do I understand from that that you are saying that what the court should infer from the narrowness of the response is that, in truth, the matters in the first sentence, the honest statement by the Prime Minister of the government's position, that in truth that is not the only scenario in which the Prime Minister either intends or may act so as to frustrate the intent of Parliament? You're inferring that, as I understand it, from the narrowness of the response. Is that correct?
My lord, is absolutely correct. And we do that not by mere assertion, but through evidence base. In fact, I've given the court one example. Can I just show you?
So I just want to get the answers first before we can start getting.
Yes, is the answer, my lord.
The answer to that is yes, but then can I, in a sense, reiterate the point made by my lady, which is, if that was your position, shouldn't you have had a supplementary request saying, are there any other circumstances in which you can act short of the answer to question 2, sending the letter saying it's valid and so on? Shouldn't you have followed that up with another request asking the government to say whether there are any other circumstances, rather than just leaving it to submissions and evidence?
My lord, if the timetable was not with a guillotine at potentially 1 minute past midnight tomorrow, my lord, we would say that would be a very fair point to level against us. But we were dealing with what we contend is an extremely urgent position, where the breach might be irremediable. With that answer, the materials in the public domain, and in our respectful submission, we need to bring it forward. And that, my lord, my lady, would say in a context in which one looks at the procedural history of this. Liberty have been very careful to take a step-by-step incremental approach. They have not rushed the court. Originally, they didn't want to list it originally. They played it step by step.
Well, they originally asked for the whole matter to be heard on the 21st of October, as it happens.
Because at that juncture, my lord, the focus was on whether or not the Prime Minister would send the letter. And so it was thought appropriate to wait and see. But you will see, caveated very carefully in our grounds, the potential for the frustration principle to arise, and the need to come to court urgently if circumstances change, and we say they have changed. So in answer to my Lord Master Roll's question, that in many circumstances would be a fair question before we trouble the court to seek to try and pin down the issue with as much clarity as possible. But we would say that would not be a fair criticism in the time taken.
I'm not criticising you.
I'm not suggesting my
Not
Lord
at all.
if my Lord were to criticise us.
I'm not criticising you. I'm just trying to say what is legitimate or illegitimate for the court to infer.
But
Can I just ask you?
I'm so sorry,
press the point here. So my understanding from the papers, but please correct me if I'm wrong, is that the government did answer your request very, very shortly after it was made, within hours. Is that right?
Within 2 days, my Lord.
Within 2 days. And so just to, you may say unfair, but I just want to press the point, to test your response to me by saying there was no time. Well, we are now where we are today, and that response was on the 9th of October. Why was it not possible immediately to take the point that you're taking now and to say, yes, well, are there any other circumstances? And that could have been done well before today.
Well, because, my Lord, ultimately, we say, with hindsight, we were justified looking at the defendant's skeleton argument today. So on the defendant's case, they say the Act doesn't give a general requirement of the Prime Minister to seek an extension. So as long as he delivers the letter, he is free to do anything else to get the European Council to refuse. And they say the frustration principle doesn't apply, not least because you have to have an effect in order for it to apply, not just an intent. And we say that evinces an, I'm sure, inadvertent, unlawful approach. And so all we would have got...
So which paragraph was that? I'm sure you said it. Just remind me again the paragraph in the skeleton.
In my little friend's
Yes,
skeleton.
just remind me again.
Well, you'll find they deal with the interpretation of Acts over a number of paragraphs and frustration.
It's a general point.
But in general, I'm summarising. I hope fairly. They say this doesn't create a general duty. As long as the Prime Minister sends off the letter, he can procure a refusal through other means. And they say. Thank you very much.
Well, on this, sorry to interrupt, but while you're there, if you're making these submissions, it may be as well to remind the court, I probably should have done it when I was making my submissions, but the answer to the request quotes a limited bit only from paragraph 17 to 18 of the summary grounds. It may be worth going back to paragraph 18 on page 82 of the bundle of the summary grounds, because they do there go beyond what is simply referred to in the answer to this request, in terms of what the government can do, including in particular pointing out that it doesn't purport to dictate what position can or should be taken in the delicate ongoing negotiations. That's paragraph 18 of the summary grounds. So you do need to read the entirety of them together.
I'm very grateful for that. But my point remains, we now have the position to then ask the court to list has been subsequently justified when we see what the defendant's position is, both as to the interpretation of the Act and the frustration principle. Now, if our arguments on both those points are correct, then the government is in fact setting itself up to act unlawfully, or may already have acted unlawfully in seeking to procure a veto or a refusal. And so I hope that answers my Lord the Master of Rolls' question. But the final point I wanted to make on these Part 18 requests and the nature of the request that we asked under question 1 is it has to be seen in not simply in the context of the defendant's pleaded case, but in the context, as I put it, with the facts on the ground. And we've been very careful to try and evidence that. And it hasn't been challenged. And I can just give you an example pertinent to the Part 18 request, to give you a sense of it. If one goes to Ms. Spurrier's first statement, which you'll find it starts at page 152. But if I could just ask you, by way of example, to read paragraph 59 and 60, which you'll find on page 166.
In the core bundle.
In the core bundle.
Sorry, I'm looking at it in the original.
Page.
166, my lord. Paragraphs 59 and 60.
Yes, thank you.
I'm sorry, I've gone wrong with the page number. It's my fault entirely. Could I have the page number again?
166, my lord. In the core bundle. And paragraphs 59 under the heading 4th October.
Oh yes.
And 60 under the following day. Now, Sir James, of course, is right to draw to your attention that this type of material, or at least submissions based on this type of material before the Scottish Court, but that's not the point I'm making. The point I'm making is this provides the context for the concern as to the answer to question 1 to the Part 18 requests that was not articulated as we understand it before the Scottish Court. And that is a highly material difference.
Precisely what wasn't articulated.
The additional, so the non-answer to the full question and the additional words about the Prime Minister being able to take acts, albeit in the limited context to which he's referring, but being able to take acts with the intent to secure a refusal, that wasn't before the Scottish courts. And our concerns as to why that makes a material difference need to be seen in the context of what is in the public domain, unchallenged, from the defendant during this period. So it gives rise to a very real concern, borne out, we say, by the defendant's skeleton argument in this case, that the defendant is proceeding under a mistaken view as to what the Act requires him to do, with potentially very, very profound constitutional consequences. And that is a very material difference in the Scottish proceeding. But may I make plain that even if it were not, the reasons I gave earlier, the Scottish decision would just be wrong. And you shouldn't be bound by it. You need to look at first principles and ask yourself whether this case needs to be heard now or can safely be put off till next week. With the greatest respect to Scotland, but that is a material difference. But ultimately, if it's all ad idem between the two proceedings, then
where do we end up then? If you had different decisions, as we had before, from this court and the Scottish court on the same matter, how is that going to help anybody?
well, if it was on a
Isn't the sensible course for the matters to be resolved by Scotland? Then if there's any necessity to do so, they can appeal to the Supreme Court.
my lord, that would be, again, we say with respect, a very powerful point of what the Scottish court were dealing with the substance. But to the extent I rely on the fact that this is essentially a case management decision. They're not saying you can't hear the case, they're not saying you can't grapple with it, they're just saying not now, and for reasons like I've tried to distinguish as to why they could have reached that properly. So it's not as if you're going to be faced with a Miller-type situation with competing judgments of different jurisdictions on anything of substance. This is just, when should you hear a case that, on its face, will need to be heard? So,
well, it isn't quite, because you're asking us to hear the case
yes,
today, effectively.
yes, I am.
And the circumstances that have arisen are relatively rare, I don't doubt, but one can envisage a whole range of decisions of government which are capable of being challenged in all three jurisdictions within the United Kingdom, essentially on the same basis, seeking essentially the same orders. And at first blush, it would seem extremely undesirable that should happen.
My lord, somebody's got to go first.
Quite.
And there is no reason, simply because the Scottish court has decided to defer, it doesn't make it inappropriate when this court looks at the matter for this court to take it up. That's the best answer I can give to the court's question on that. It does then take me to the question of the political context that urged upon you by Sir James. My lord, my lady, we say that if there is a prima facie case that the defendant is acting unlawfully by seeking to frustrate the will of Parliament, then the political context matters not. What does matter are the consequences of the unlawful acts, and it is irrelevant whether those have political ramifications or not. And one critical absence in everything that my learned friend submitted to the court is the question of irremediable damage. Because my learned friend can't suggest that the court could have any effective role after the EU, if the EU refuses to extend following a request from the Prime Minister. And that's really the heart of my submission on permission to appeal, as I hope is understood. The court has to grapple with it now. But the political context is ultimately, if the Prime Minister is at risk or is in fact acting contrary to the will of Parliament, then the fact of the political context is irrelevant. Could I just give you, just take you to Miller 2 very briefly, you get a little help from it. find that in volume 1 of the authorities behind tab 3. Paragraph 31. Page 601 of the report. The court said, although courts cannot decide political questions, the fact that a legal dispute concerns the conduct of politicians or arises from a matter of political controversy has never been sufficient reason for the court to refuse to consider it. As the Divisional Court observed in paragraph 47, almost all important decisions made by the executive have a political hue to them. Nevertheless, the courts have exercised supervisory jurisdiction over the decisions of the executive for centuries. Many, if not most, constitutional cases in our legal history have been concerned with politics in that sense. And then if I could ask you to look at 33, the Prime Minister's accountability to Parliament does not itself justify the conclusion that the courts have no legitimate role to play. That's for two reasons. Could I just direct your attention to the second, which is below letter E? The second reason is the courts have a duty to give effect to the law, irrespective of the Minister's political accountability to Parliament. The fact that the Minister is politically accountable to Parliament does not mean that he is therefore immune from legal accountability to the courts. So this may certainly not a question of deference, let alone non-justiciability, if in fact the defendant has an intention or has in fact acted unlawfully in the way that we contend, then we would with great respect submit that it's the constitutional duty of the court to be seized of the matter.
Well, the question is when. I mean, that was I think the substance of the point made by Sir James was that the factual position may change. That was the tenor of his submissions in relation to what may happen between now and the noon on the 21st.
Yes. Well,
It wasn't a question of justiciability or not.
my lady, our simple answer to that remains before it is too late. The question is when it would be too late, at the time of a refusal. When can the acts be taken to procure refusal? Now. The request is going to be made on Saturday night if Parliament votes against the deal or against a no deal. And it could all be over by the early hours of Sunday morning. And the heart of everything I'm saying, I'm kind of embroidering it somewhat with additional submissions, but the absolute crux of what I'm saying is the court has to intervene before it's too late, because otherwise there would be little point. Because there is on the face of the material before the court, there is at least an arguable case that the Prime Minister misunderstands his obligations under the Act, which would have potentially profound constitutional significance. It is clearly within the ambit of the court, we say with respect the duty of the court to grab it, and it can't, by case management, essentially abdicate that responsibility. So with great respect. And the fact that we are in the 11th hour in respect to the parliamentary process, we say makes it all the more important that the Prime Minister is clear as to his legal responsibilities before it is too late. My third point was to go back to the order of Mr. Justice Supperstone, which does essentially no more repeat than submissions I made, and I'm not going to do so. But if I could just ask the court to pull it up, it's at 150 of the court arm. His Lordship gives his reasons. I'm saying there are no good grounds for it taking place, and that following Vint 2, the decision can only be ascertained at midnight on the 19th of October when the position is significantly clearer, and those observations apply to the present proceedings. Well, great respect, that we say the Loon Judge was simply wrong for the reasons that I've given. It's not so much a discretionary view that he's come to in terms of when generally is the most convenient time to list the case. In a case in which he's presented with a hard-edged case that one needs to act before this given date, we say, for the reasons I've already set out in my submissions, he was wrong, simply wrong to say that the better time to deal with this is once it's too late, or may very well be too late.
Yes. And that comes back to your submission that both the outer house and the inner house were wrong to come to that conclusion as well.
Well, that's not my primary submission, my lord. My primary submission is that the position was not the same as presented to Mr. Justice Supperstone or presented itself in this court for the reasons I went through with the significance of the Part 18 requests and the additional line is actually very material when seen in the wider context of what the defendant has been saying in public as to his intent. That's my primary. But ultimately, if this court can safely conclude it was precisely that position for the Scottish court, then ultimately, yes, I would be driven to say, and would say, that they were wrong. And it certainly shouldn't prevent this court from looking at the matter and reaching its own conclusion. So, of course, a case management decision in essence, but if the Lily Judge was simply wrong in the case upon which that decision was made, then this court can safely conclude that it falls outside the ambit of what would be a reasonable decision. You can't make a reasonably wrong decision. My final point is on flexibility inherent in the way that courts of England and Wales engage with important public law matters of urgency. And we say it is one of the great aspects of public law in England and Wales that it is able to grapple with things of importance quickly. And whilst, of course, all respect must be given to Mr. Justice Supperstone's decision, this court too should approach this issue conscious of the flexibility that the public law courts in this country proffer. Of course, I'm not seeking to suggest that simply because we are here, or parties are prepared to argue a case, that means an appeal court should go, well, seeing as we're here, we're here. Of course, that's not right. But in the context of this particular case, my lord, when the parties are fully prepared, when nobody is arguing vigorously at this stage that the case should be dismissed because it is hopeless, where it touches upon matters of real public importance, where we have set out a prima facie case, and we are ready to go, better to do it now than to wait till next week or the week after.
Mr. Herman, we'll rise now to see where we are.